Welcome to Husch Blackwell's Labor Law Insider Podcast. This is your host, Tom Godar. I've been practicing in the labor law sector for, more than 40 years, and I can tell you that in no time of my practice has labor law had greater changes than in the last 5-6 years. We began the podcast in May of 2021 following the election of President Biden, and elections have consequences, and under the Biden administration, a new National Labor Relations Board with a new general counsel reshaped labor policies, and they were very consequential. During that time, because it was so important to stay on top of labor law issues, the family of Husch Blackwell Labor Law Counsel more than doubled in its coast-to-coast reach to assist our client. Well, we've since had another election. In the January of 2025, President Trump was inaugurated to his second but non-continuous term. And once again, we're seeing significant changes in how the National Labor Relations Board and its appointed members, the GC right now an acting general counsel, and the board members are going to interpret the National Labor Relations Act and its associated laws. So once again, we're continuing a wild ride of labor law. It's not likely to change soon, so buckle up and enjoy the Labor Law Insider Podcast. It is so great to be back, and you are really going to enjoy our Labor Law Insider Podcast today. A little bit different, a lot of fun. It's going to be focused on non-compete agreements and their progeny that sometimes are non-solicitation agreements, and their friends and cousins confidentiality agreements. But there's been changes that affect all of our clients and friends over the past decade, and it continues to change even over the past year or two as states become more and more involved in revising their own non-compete laws as they've sort of waited on and then decided that the feds really aren't going to step deeply into this territory. Of course, we're going to go into detail on all of that, and we're going to do it with some really terrific guests today. Tom O'Day is joining us. Tom's been a frequent visitor and true insider, sharing his insights and experiences with us. And Tom, it's so good to have you back. Tom's a UW grad, practices primarily out of our Wisconsin office in Madison. But Tom, tell us a little bit about yourself and what's going on these days with Tom outside of litigating or advising on non-compete agreements.
Sure. Well, I appreciate the opportunity to be back with the Labor Law Insider. So I am in the midst of the start of football season. I'm excited. My son is on track for 9-sack season after one game with 1 sack, which is extremely exciting. And we've got another game this evening, and then our youth program kicks off this weekend as well. So excited for the football season, both at the youth, the high school, and college level as well.
You're an incredibly busy guy. Tom, are you also coaching, or are you just an ardent fan for your youth football for your kids?
More on the ardent fan side.
Great. Now watch your tongue there in the stands there, Tom.
Exactly.
Great to have you on board. And Tom and I have worked together on some of these non-compete issues, and it's great to have you. We also have a newbie insider for our day. This is Tracey O'Brien. Tracey is one of our colleagues and practices out of our St. Louis office. She's been with the firm many years and came in shortly before the torrid times of COVID and all of that sort of thing, and has been really a rock-solid part of our team. In fact, she's been recognized by J.D. Supra in the Reader's Choice Award as the top author for labor and employment, and she certainly has co-authored and helped me, quite honestly, oftentimes as I've drafted articles and so forth. Tracey, it's great to have you joining us.
Thanks, Tom. It's good to join you and Tom on the Labor Law Insider today.
Well, tell us just a snippet of your journey to this area of labor and employment in which you find yourself practicing full-time with Husch Blackwell.
Sure. Well, I started out in a compliance role in the federal government, moved into private practice and became an employment law litigator. And then I returned with Husch Blackwell to another compliance role, assisting federal contractors with their compliance obligations with the federal government. So, Tom, I've come full circle.
Well, it's great to have you join us, and it's fun to have different perspectives and a little bit different topic for our listeners today on the Insider. Lots of stuff has been going on under the Biden administration and now the Trump administration at the federal level that relates to non-competes and broad or narrow bans or no bans at all. Tom, why don't you refresh us a little bit on the journey and where we stand today as the federal agencies get involved in areas of non-competition agreements and whether they're enforceable and so forth?
Sure. So I think a nice place to start would be just to review the definition or what is encompassed by the term non-compete agreement. And I always look at this as 5 different types of a restrictive covenant. There is an agreement that an employer or company might entertain with their employees to protect their trade secrets. A second type of agreement is an agreement to protect an employer's non-trade secret, but still confidential information. A third type of agreement would be an agreement restricting former employees from soliciting other employees of your company. So that might be an employee non-solicitation, or sometimes called an anti-rating provision. A fourth type of agreement would be an agreement restricting former employees from soliciting other customers or vendors or suppliers or patients. That would be a non-solicitation restriction. And then the fifth type of agreement, the one that I think most people think of when they hear non-compete, is an agreement restricting the geographic scope within which a former employee can work in a competitive environment. So that fifth type of agreement, a non-compete, a geographic restriction, might say something like, I agree that I won't work for a period of 2 years within a 25-mile radius of this office at which I worked for this company. That would be, I think, what most people think of in terms of non-compete agreements. And I think it's important to recognize those different levels of a restrictive covenant, because their interest in the federal government in going after different types of those varies and is varied by different presidential administration.
Excellent primer, and wonderful to sort of play out the field a little bit, because as we draft these for clients or look at them for enforceability, we look at each of those and say, there may be a different analysis on each one. So tell us what's going on the federal side, Tom, regarding non-competes and the various iterations as you describe them.
Sure. We know from our labor law practice that, especially with the National Labor Relations Board, there is quite a swing in the pendulum of how the National Labor Relations Board interprets and then enforces the law with respect to federal labor law. And with one administration, it swings one way. With the next administration, it swings the next way. With the Biden administration, it was really the start of, it started with the Obama administration, but it wasn't as much of a focus. But with the Biden administration, they started pretty quickly with an effort to go after non-compete agreements or restrictive covenants more broadly in the American economy. And it was a July of 2021 executive order from President Biden that set the standard for his administrative agencies like the National Labor Relations Board, the Federal Trade Commission, and others to really go after and have non-compete agreements or restrictive covenants in their target. And that led to a number of different shifts in federal policy that were aggressively looking to prohibit these non-compete or restrictive covenant agreements and restrictions.
So we have the start of federalizing through administrative action. That's what we're talking about, not through legislative action. The idea that non-competition agreements are a restraint of trade or monopolistic. So the FTC gets involved and the NLRB gets involved, saying you're imposing upon collective action. And as a result, having these kinds of agreements may be itself an unfair labor practice. Are those all gone away, or is there something left to talk about on this federalizing through administrative action, Tom, in 2025?
Sure. It has been interesting. In the first now 7 months or so of the Trump administration, President Trump has started making indications, and his administrative agencies have started making indications that they are going to move away from what President Biden had done. And it came on a couple different levels. Just recently, with the National Labor Relations Board, the interim general counsel, someone who was appointed by President Trump, rescinded a memorandum that had been issued under the Biden administration and did away with the prohibition. Now, after the interim general counsel did that in February of 2025, there was still some unknown of how would the Trump administration, the Trump National Labor Relations Board, interpret restrictive covenants or non-compete agreements going forward. And we just recently, in summer of 2025, now have an advice memorandum from that same interim general counsel, where that general counsel was taking a look specifically at an employee non-solicitation restriction that said for a period of time, an employee won't recruit or solicit his or her former coworkers, and also a patient or customer or client non-solicitation restriction. And this interim general counsel of the Trump National Labor Relations Board effectively said those types of restrictions are not unlawful under the National Labor Relations Act. Now, there's a little bit of language that isn't making this generally applicable, but I think it's a good sign for the National Labor Relations Board that they do intend to move away from some of that aggressive enforcement that sought to prohibit non-compete agreements or non-solicitation agreements that happened during the Biden administration. And that's important for employers. These non-compete agreements, these non-solicitation restrictions, these confidentiality restrictions are really important for the business of companies. And I can recall a conference I was at with a United States senator and a trade association, where one of the trade association members spoke up and said, it was during the Biden administration, and said, this is a big problem for us because we invest so much in our employees with training that we might do for them, with the information that we share with them, both at the trade secret intellectual property level, but also non-trade secret confidential information. And this leader of a company said, we do need to take steps to protect that information. We're fair about it. Our employees are getting something in exchange for their promise not to solicit our employees or compete with us once we train them or give them access to that important information. So it's really an important business need to protect their assets and their investments that they make in the employees. And ultimately, it comes down to whether it's fair or not fair.
That's a terrific summary, and we'll make sure that we have in the show notes, we'll have a link to that advice memorandum that you just talked about, Tom. So right now, the feds are not out of the game altogether, but there's not a sort of stampede towards federalizing, if you will, non-compete prohibitions through either the FTC or the board. That, of course, means that we're back where we always were, which is that we have a patchwork of state laws that vary quite significantly, that really inform our clients and our friends and employees about what might be a reasonable restraint on their post-employment activity and what might be found to be unreasonable and therefore prohibited. Tracey, why don't you give us a sort of idea of what's taking place in the consequential return of enforcement, if it ever really left, to states as it relates to non-competes, and I'm using it in the broadest sense that Tom introduced when he first started.
Sure. Well, as the federal government policy shifts on enforcement of non-competes, it will be the states that continue to take the lead role in regulating non-compete agreements. And we've seen this, for example, in 2025. In 2025, 16 states enacted state statutes that either imposed new requirements with regard to non-compete agreements or updated existing restrictions on non-compete agreements. So the trend that we see is that the states are tightening those restrictions on the use of non-compete agreements. And as you mentioned earlier, employers, especially multi-state employers and employers with a large remote workforce, will have to comply with a variety of state restrictions. When I think about issues related to non-compete agreements and compliance with these state laws, we can divide the states into two different types of categories or buckets. And those categories are states that completely ban non-compete agreements. And in the second category be those states that permit non-compete agreements, but with restrictions.
Well, walk us a little bit towards some of those and give us some insights into those states and how employers are responding.
Sure. There are 4 states that impose complete bans on non-compete agreements. And those states are California, Minnesota, North Dakota, and Oklahoma. With regard to these states, it's important for employers to focus on three primary issues. The first is the scope of the restrictions within the state statutes. The second is any additional obligations imposed on employers within those state statutes. And third are the penalties that are for violation of the state statute. For example, in Minnesota, the Minnesota statute prohibits non-compete agreements with employees as well as independent contractors beginning on July 1st, 2023. But they do permit other restrictive covenants such as non-solicitation agreements, trade secret agreements, and confidentiality agreements. However, if an employer violates the Minnesota non-compete statute, however, there is a private right of action that employees who are successful in enforcing their rights under the Minnesota statute have a number of remedies available to them, including injunctive relief, damages, and reasonable attorney fees. California, however, has a long history of banning non-compete agreements as a matter of public policy. Despite that long history, they continue to enact additional laws imposing obligations on employers. And in 2024, they passed and enacted two laws which impose additional requirements on employers in Senate Bill 699 and Assembly Bill 1079, both of which were codified at the California Business and Professional Code section 16600.5. Under those statutes, California employers are precluded from including a void covenant in a contract. And they're also precluded from attempting to enforce a void contract. In addition, in California, the employers must notify in writing former and current employees who were employed beginning in January of 2022 that a non-compete agreement that they previously had entered into is now void.
Stop there for a second, Tracey. Help us understand, what do you mean they permitted a void provision?
So that's right, Tom. In California, the California legislatures are concerned that employers are continuing to include in employment contracts a non-compete provision, which the concern is that these non-competes, even though they are void, will have a chilling effect nonetheless on employees and their choice of moving to new jobs.
Yep. Sounds a little bit more like board law, which is, I don't care if you've tried to enforce this, if it's in your handbook, if it's in your policy, and it chills the opportunity for people to engage in collective concerted activity, we're going to find it a ULP, even if you've never disciplined or used it to curb that. So the same kind of idea. Don't even try to put it in under some hope that maybe it'll slow down the train.
And I think, Tracey, if I'm right, under California's law, it is against the law to include any type of agreement or provision that would restrict that type of trade, a non-compete agreement, a non-solicitation agreement. And that's pretty significant for the reasons that you both articulated. I'm not aware that any other state has that level of prohibition.
I agree, Tom. Non-solicitation and non-compete agreements are both prohibited in California. They do allow trade secret agreements and confidentiality agreements.
Well, that has been terrific, Tom and Tracey. I appreciate that, but I'm going to stop this portion of the recording right now as part one and join the Labor Law Insider for part two as we continue our discussion now primarily on the state-specific issues that people have to be aware of. And it's not only just states, but within states, there's all sorts of discussion as to how particular occupations or levels of payment or exempt, non-exempt employees can be affected differently. And please join us as we move into part two to learn a lot more of the granular parts of non-compete agreements that you're going to have to be aware of depending upon your jurisdiction or your multiple jurisdictions in which you operate. But thank you so much, Tom and Tracey. We're going to be hearing from you again in just a week or two as we publish part two of our Labor Law Insider dealing with restrictive covenants. And thank you, listeners, for joining us on the Labor Law Insider.